Good evening, ladies and gentlemen. It's a great pleasure to welcome you all here to the fourth series of the Humanitas Lectureships in Women's Rights, which is run out of CRASSH, whose director I am. I'm Simon Goldhill, and with the sponsorship and support of the Institute for Strategic Dialogue, who I can see over there. Peter, thank you. Nice to have you here. And we're extremely thrilled to have this year Mona Siddiqui from Glasgow, who's going to touch all the bases for us. It's feminism, religion, women's rights, everything we wanted to talk about in this series. And we're thrilled that she's been able to come down today to give the first lecture. She'll be speaking tomorrow at 5 as well, and on Wednesday at 5. And then there's a symposium in CRASSH on Thursday at 2. And if you'd like to come, you're very welcome. There will be some excellent speakers there responding to the series as a whole. The only thing we ask is if you can sign up before you come on the CRASSH website, that helps for the cups of tea. Otherwise, it gives me great pleasure to introduce this year's Humanitas Lecturer Professor in Women's Rights, Mona Siddiqui.
Thank you, Simon, and thank you, Michelle, for looking after me when I came, and thank you all of you for coming this evening. All three lectures, as Simon has referred to, are quite different. Tomorrow's is on Mary in the Islamic and Christian tradition, and on Wednesday I'll be looking at where we are in Islamic thought and in Islamic images of women in terms of feminism and feminist. But today's title is probably my favourite title, Can You Text a Divorce? Though it sounds like a flippant title, but it's actually quite a serious matter. And in this paper, what I'd like to do is say something about the classical juristic tradition of Islam, which compelled me to raise this question in the first place, and then say something about the nature of divorce law, and finally the question of whether a divorce, which is a text, can indeed be considered as an effective divorce, according to the Islamic classical tradition. The aim here is not to comment on the frequency and spread of this issue in contemporary life, but basically how it poses a conceptual legal challenge and, I think, an increasingly ethical dilemma for Muslim communities. The history of the Islamic intellectual tradition developed on the premise that all the varying oral and written traditions were somehow a reflection of the need to analyse the God-man relationship. The many different styles of pious reflection, such as kalam, fiqh, tafsir, tabaqat, and sirah, just a few examples of how scholars try to make sense of a revelatory process that for them saw a formal seal to revelation with the death of the Prophet Muhammad, but emerged as a living socio-intellectual phenomenon only through the interpretation and comment of the living community of subsequent generations. These works and disciplines, along with others, form an Islamic canon of some sort, to which the faithful return for meaning and which are subject to the whole process of selection and revision through different generations and cultural communities. In Islam, religious law and scripture are intimately tied, but remain quite distinct sources of authority. Traditional academic wisdom has often said that Islam, like Judaism, is a religion of the law, a definition which is often characterized, in contrast to Christianity, within the simplistic phrase that these two faiths prefer the letter over the spirit. In speaking for Islam, I would argue that whereas the law became the prominent literary discourse in Muslim thought, its goal was not in antithesis to the ultimate aims of theology or philosophy, that is, an understanding of God or the transcendent. By outlining the ways man worshipped and behaved morally in society, the aim of the law was not to elaborate the doctrine of God, but the doctrine of obedience. How does one draw near to God, and how does one invoke God daily within life and outside of formal worship? Strictly speaking, Sharia, which is usually used as a shortcut for Islamic law, refers to God's law as it is with God and his prophet, in which is to be found an ideal of Islamic thought. In its simplest definition, however, Sharia is not law as we understand law in the modern world, that is, a set of regulatory rules and regulations. Sharia is contained within the corpus of the Quranic revelation and in the precedent set by the prophetic way of life, the Sunnah. Fiqh, or understanding, on the other hand, is really the science of jurisprudence. It embodies the efforts of qualified scholars to discover and discuss within a particular literary tradition the principles of Sharia law. Fiqh, therefore, covers a wide range of subject matters, including public welfare, personal morality, personal law, finance, and, of course, dietary laws. The discipline developed neither as an unequivocal nor as a monolithic expression of God's will. It became rather a scholarly discourse in which religious communities interpreted the sources, in different ways, and which both agreed and disagreed on essential legal and moral matters. But their aim was to explore right and moral behaviour, not just with respect to worship, but to all aspects of human relations. Juristic reflection therefore came to some degree sacred law. Human reason had to be applied for the elaboration of Islamic law. The best effort applied by each scholar jurist to assess and determine any one ruling from the text of revelation to the norm of law was contained in the concept of ijtihad, or personal reasoning, and legal theory became known as the roots of law, the principle or roots of fiqh. By virtue of independent reasoning, a vast body of positive rules came into being, defined as the branches of law. These books, which laid out the scholar's knowledge of the law, encompassing in theory all aspects of life and worship, the type of jurists engaged in the thinking, application and judgments of law, they're all contributors to the development of what is called religious law in Islamic thought. But it's my contention, along with many other scholars today, that jurisprudence was never more than a human approximation of a sacred ideal, a product that was ultimately a pious but human and therefore imperfect effort. It saw limitless growth at the hands of the jurists, whose writing style combined juristic speculation with literary ingenuity. While there were several schools of law in early Sunni Islam, the groupings of these jurists eventually settled out at 4 main schools. According to medieval Islam, these schools were named after their founders, Malik, Abu Hanifa, Shafi, and Ibn Hanbal. Many Western scholars have argued that the founders of these schools were not responsible for establishing the schools named after them, but it was the pupils of these founders who established the basic elements of the school. There's no real evidence or any historical consensus as to why only 4 schools of Sunni law were accepted, but there are also Shia schools such as the Zaydis and Ithna Asharis that developed separately. As the 4 schools became established, jurists of individual schools wrote according to the methods and disciplines of that particular school, despite spatial and temporal differences. There were 2 ways by which the views of different writers from different eras were established. One was through the exploration of those problems which each generation of jurists inherited from their ancestors, and the other was through the citing of past authorities. This was the way in which tradition was affirmed and embraced, surviving not through inertia, but through the active preservation and participation by generations of scholars. The richness of juristic speculation within each school and across schools is contained in the diversity of juristic opinion. Ikhtilaf, the central stylistic feature of fiqh. The principles of disagreement allowed the juries to put forward various perspectives on a single point of principle by the discussion of options and circumstances. Fiqh, therefore, or jurisprudence, acquired a technical life in the creative ingenuity of the jurists. These principles often became buried under the mound of detail and formula. The diverse legal opinions are presented through a casuistical approach, where priority is given to the creation rather than application of the law. The texts accommodate a selection of viewpoints on a given issue by citing a large number of different authorities. These authorities remain equally important. Throughout the centuries, the huge mass of jurisprudential literature reflected the social and moral interconnection of rules and principles. But it's important to understand that jurisprudence did not state law as we understand it in the modern sense. However, the jurists understood the vast corpus of this literature which they produced as a pious as well as a scholarly exercise. The relationship between Sharia and fiqh has remained complex. As Wallah writes, some view the two as inseparable, maintaining that the Sharia can only be known by fiqh, while others draw sharp division between the always time and place specific tradition of fiqh, and the universally valid revealed law of Sharia. Over the last 2 decades, scholars have focused much attention on the historically prescriptive nature of Islamic law and how much of this tradition can continue to be valued as a normative law in any real sense. The cry among some scholars, such as Fazlur Rahman, is that Sharia is positive law. If Sharia is positive law, it is not always consistent with the ethical and moral imperatives of the Quran itself. There are those who claim that in regarding the classical heritage as an immutable body of law, Muslims have ignored the essence of Islamic law in society. That is, whether in application or content, it was always changing. They state that even where modifications have been made or the laws have been subsumed within post-colonial Western legal codes, the Muslim world has tied itself to conceptualizing human relations within a largely medieval framework. Others claim that these juristic works are the repository of pious reflection by men who had interpreted the fundamental sources of Islam, so they contain within them the resources necessary for rethinking of social and legal attitudes, and also for the revisioning of Islamic societies. The claim is that in general, Muslim attitudes to Sharia have been hugely varied, and the nature and validity of many aspects of Islamic law have been contested. However, the principles that lay behind the formulation of law can still be applied today to develop new thinking that would be in line with more contemporary notions and standards of human dignity and more universal principles of human freedom. Most commentators on Islam in the West do not draw or know of any distinction between the two terms. Islamic law is used as the most common translation of the word Sharia, which in itself is the umbrella term to signify all aspects of religious and cultural legalism. That which is Sharia is God's law. That's usually the definition. This perception is fortified by an increasing predilection in popular Islamic piety to describe or justify individual acts as in accordance with Sharia, with little desire to raise awareness of the nuance and diversity which is an essential aspect of legal literature. If anything, Muslim discourse around Sharia has in current times used the term as a simplistic mark of distinct ritual and political identity. It would be no exaggeration to say that despite a general awareness of Sharia as Islamic law, for most non-Muslims in the UK, Sharia was quite simply a foreign word with a foreign vocabulary. And all of this changed after the London bombings in July 2005. The counter-terrorism police operations were suddenly plunged into multiple cases of suspected bomb plots, cases where the written material which they found was full of words and theological concepts which had little or no meaning for them. Words such as kafir and jihad featured frequently in the literature found in many of the suspects' homes. While many in the police and security forces came to grips with some of the more general vocabulary, it was soon apparent that an in-depth knowledge of Islamic sources was fundamental to any successful operation, and where applicable, subsequent conviction. This whole area has been complicated by the Terrorism Act of 2006, which creates offences relating to the sale and other dissemination of books and publications, including material on the internet, which encourages people to engage in terrorism or provide information that could be useful to terrorism. Many scholars of Islamic studies in British universities have been approached to help as legal experts, people who can shed light on some of the more complex arguments of classical Islamic law, especially in the areas of military jihad. Some have refused to participate on the grounds of individual principles, while others have been more than willing to be of service. Alongside the acquisition of this specialized vocabulary, an increasing number of family and criminal law cases involving Muslims are also coming to British courts. Many of these cases require expert reports from academics well versed in different areas of Islamic law, or at least from those who are competent in the methodology of reading classical Islamic law. These cases aren't just about marriage or divorce laws, but also about adoption, custody, and issues pertaining to sanity and legal competence. Nevertheless, through the analysis contained within the expert reports, the complex world of classical Islamic law is unusually but slowly opening up for many British barristers and solicitors. This process, however, has not caught the imagination of most policymakers and media pundits who continue to see little in Islamic law except for draconian punishments. When looking at jurisprudential literature, one may well ask, how can this function as law in any contemporary and concise sense of the word? This is especially so when one explores the casuistic nature of Islamic law. So let's look at divorce, talaq, but start with a few words on marriage. Marriage and divorce laws touch upon some of the most significant aspects of human relationships. Indeed, in the Quran, many of the verses which refer to women refer to them largely within the context of marriage and divorce. The verb to marry and its derivatives are the closest terms used to encapsulate marriage and the different aspects of marriage, even though the verb means other things as well. Fundamentally, the term nikah implies a legal contract between a man and a woman who are of competent age and competent mentality. A social institution, but it also means a physical act of sexual intercourse. Marriage is referred to in various contexts in the Quran, and the Quran orders men to marry women of their choice as an option. It also affirms human sexual needs and sees marriage as a desirable and permissible remedy for natural passions. There is a Quranic verse which is explicit in urging restraint in circumstances. Let those who cannot afford to marry keep themselves chaste until God enriches them from his bounty. A prophetic hadith also emphasizes the importance of marriage as a relationship for fulfilling sexual needs. Whoever is able to marry should marry, for that will help him lower his gaze and guard his private parts, in brackets, from committing illicit sexual intercourse. Marriage and divorce in Islamic law are discussed primarily as oral contracts, based on offer and acceptance. They are based on performative utterances. That is, what you say changes your status. The Quran's main verse on divorce is, divorce can happen twice, and each time wives either be kept in an acceptable manner or released in a good way. It is not lawful for you to take back anything that you have given them, except where both fear that they cannot maintain the marriage within the bounds set by God. If you suspect that the couple may not be able to do this, then there will be no blame on either of them if the woman opts to give something back for her release. This is a general framework of release from a marriage contract, and both husband and wife are permitted to end a marriage contract in different ways, but which recognizes liability of some financial compensation on each of them. In the same way that the Quran does not mention any verbal formulae for entering a marriage contract, other than the intention to complete, the Quran is also silent on any verbal formulae to end the marriage contract. Although intention is an important theological concept in Islam, which also has legal relevance, express and clear statements of marriage or divorce do not require the presence of intention to make either a marriage or divorce valid. Okay? So as long as you say the words, even if you didn't mean them, they can amount to marriage or divorce. While there are various ways of ending a marriage contract, such as annulment, separation, and judicial dissolution, including the khul for a woman, a separation by talaq divorce is a prerogative of the husband only, and the Quranic verses address the procedures for divorce to men. However, when divorce has been initiated by the husband and wife continue to have rights over each other until the divorce is final. The key elements are that a divorce is permissible twice, after which both husband and wife must stay together or separate. If a husband divorces his wife a third time, the divorce then becomes irrevocable, which means there is no possibility of a reunion and the two must separate. They cannot remarry until the woman has been married to another and divorced by him. The Quran does not say if a man divorces a woman 3 times. It says, so if the husband divorces her, she is not permissible to him. The third time is inferred from the preceding verse, which says that divorce may take place twice. A woman who is divorced must observe the waiting period of 3 months or the duration of her pregnancy. And if she happens to be pregnant at the time of a divorce, that is until she delivers. During this waiting period, a husband and wife can be reconciled by laying claim to each other, emotionally and physically, in which case no divorce would actually ever have taken place. Only a preliminary proposal to divorce by the husband. A woman can also be divorced prior to the marriage being consummated, and the husband can divorce her both irrevocably or take her back. When looking at the juristic texts, it would seem that it was the rather ambiguous nature of these two verses which concerned the jurists. The Quranic verses outline certain procedures, but as divorce is also realized through the spoken word and can be a staged process, Muslim jurists looked at the possible complexities arising from both the form and the oral content of divorce. The possibility of taking a wife back after having intimated a desire for divorce led to a variety of forms of divorce, as well as variations on when exactly divorce becomes final. While allowing for only 2 divorces before divorce becomes irrevocable and binding, abrogated a pre-Islamic practice when men could divorce and take their wives back many times, the problem of right time and right number relating to divorce remained. While right time was understood to mean a woman's time of purity as opposed to her menstrual cycle, right number was complicated by the possible revocability of divorce, and a variety of interpretations arose from the apparently simple exhortation of divorce is twice. Thus, talaq in itself does not always mean an immediate dissolution of the contract, but only an intention to dissolve the marriage contract. The English word divorce is misleading in translating the Arabic talaq, because divorce denotes the termination of matrimonial relations between husband and wife, while the Arabic talaq is regarded fundamentally as a process of repudiation, but which could possibly lead to a final dissolution or a reconciliation. The exception to this in Hanafi law, which is one of the largest schools of law, may be when a divorce is pronounced before the husband has consummated the marriage contract. While divorce is regarded as a thing most hated by God and to be avoided at all if all possible, the innovative divorce, it gets even more complicated, or the triple divorce, which is where a man can say, "I divorce you 3 times in a row," was considered unlawful at first by most of the Sunni schools, but then came to be accepted as sinful but legally valid. As Nihaluddin Ahmed writes, despite clear Quranic injunctions to the contrary, immediate triple divorce is permitted, destroying marital life in one breath. The practice of immediate triple divorce is widespread among Sunni Muslims and has legal validity. Even then, the jurists call it an innovative form of divorce. The dispute has been highlighted by reports of some Muslims instantly divorcing their wives by email, over the phone, and even through texting. One could expect a certain level of emotive language in discussions on marriage and divorce, but law does not deal overtly with sentiments, but only rights and consequences. Hanafi law looks at marriage through a particular contractual lens. In this contract, marriage is essentially arranged between the parents or guardians of the bride and groom, and notions of romantic love or desire as an emotion between 2 people prior to marriage have no place. In the talaq divorce, however, intention to separate lies with the husband with no dependence on any elders or parents. In both situations, a legal divorce is a pre-modern discourse. Islamic law is concerned with the oral statements and diverse formula which could lead to the first stages of divorce and eventually a final divorce. Talaq was purely patriarchal and a unilateral privilege reserved for the sane and the adult husband. But the jurists tried to put some balances and checks on this right, namely by ensuring that the woman or the wife's rights are observed. The spoken word carried enormous weight in divorce pronouncements, and it was important to ensure which verbal formulae constituted divorce, as the consequences affected people and property. The following are very brief examples of an ingenuity of legal casuistry which allows for all kinds of different pronouncements of divorce to be considered valid or invalid. Just 2 short examples, and they are a bit confusing, I'm afraid. And if he says you are divorced yesterday and he has married her today, then there is no effect. The reason is that he has based the divorce on a time already past, negating the right of ownership. It is ineffectual, as if he were to say, "You are divorced before I was created." If he says, "You are divorced before I marry you," there is no effect. This is because he has based it on a negating time. It would be as if he were to say, "I divorced you as a minor or as one sleeping." I have to say there is absolutely no evidence that people actually said these things, but it's a game that the juries play in order to understand what words would affect an actual divorce if somebody did say this. Then there are the formulae which begin with, "If you do this, or each time you do this, you are divorced." The lengthy discussions of formulae all reveal the importance of the spoken word. So my question is, how then can a husband text a divorce, and is his texting the same as speaking? In 2003, the BBC website reported, "Getting a quickie divorce has taken on a whole new meaning in Malaysia, after it was decided that a man can divorce his wife with a text message." The government's advisor on religious affairs, the man who counsels Malaysia's Prime Minister at the time, said as long as the message was clear and unambiguous, it was valid under Islamic Sharia, because texting is a form of writing. The response by many women groups, including the famous Sisters in Islam, a women's group leading the campaign for Sharia reform, said that the rights of Muslim women had been gradually chiseled away through various amendments to the Islamic family law since the 1990s. One said, "Malaysia once had the most progressive family law in the Muslim world. Now countries like Morocco, Turkey, and Tunisia are way ahead of us. The religious belief of subservience to men is still dominant." Masna Muhammad from the University of Singapore writes, "It would seem that Sharia is now being used extensively to confer special privileges to Muslim men by way of liberalizing their options for marriage and divorce, rather than to incorporate more regulations ensuring that they abide by their masculinist protector role towards the family. In this regard, the transformation of the Sharia is moving from it being a judicious moral code for familial life to becoming a rigid doctrine for delimiting the boundaries of the exactly authentic Muslim family. In the Malaysian context, the Sharia has been transformed from a moral code of conduct for familial relationships into becoming a formulaic doctrine for authentic Muslimness. In the process, various social distinctions have surfaced, particularly when marriages are being dissolved. With successive amendments to the Islamic family law, the gap between men and women's rights and entitlements has widened. Marital dissolution, which is one of the most traumatic experiences of family life, deals an added blow to Muslim women, as their option to exercise their rights in sustaining or dissolving a marriage, as well as their entitlements to a fair, just, and equitable post-divorce settlement, are increasingly restricted. In 2003, in Cairo, there was a headline, "The Cairo woman stared in disbelief at the text message in her cell phone box. She and her husband, an Egyptian officer, away on duty, had just hung up after quarrelling on the phone. She ignored his return call. Not wanting to continue the argument, the woman recounted in an interview this week. The electronic chirrup of an incoming message signaled his response. 'I divorce you,' her husband had written. 'That will teach you not to answer my calls.'" In 2009, a Saudi judge approved a divorce by text when a man sent his wife a text from Iraq. In 2011, an article by Angela Robson highlighted the growing use of texting in Tajikistan. She wrote, "Rose," this is the woman who told a story, "remembers a message texted from her husband in Russia, as if it happened yesterday. 'Talaq, talaq, talaq,' she says bitterly. 'That was it. My life was over.' It sounds dramatic, but for Rose, a rural Tajik woman with 5 children, the divorce was humiliating and shocking. She's just come to terms with it. No visit, no phone call, no letter. Nothing but a text. 20 years after the collapse of the Soviet Union, Tajikistan is experiencing a strange new disintegration of its own. Divorce by text, issued by men who have traveled to Russia to seek work, has become so popular the government has issued a fatwa against it. It has said it will consider imposing jail sentences for men who pronounce the talaq, the declaration of divorce, by electronic methods. Tajikistan is the poorest of the former Soviet republics, and almost half of its GDP is earned by migrants living abroad. And in 2013, religious officials in Dubai also made it permissible for a man to divorce his wife via text, as long as he hadn't sent the text in anger. Let me add something here on the issue of meher, which is the only gift which is payable in an Islamic marriage contract. Despite what you hear and see, this is the only financial material exchange of wealth. And it's important to understand this in the wider context of divorce. So the meher is in essence a debt the husband owes the wife if he divorces her or dies. The money becomes hers. He can give her half the money at the time of the marriage contract and half if they should separate, or he can give her the whole amount at the time of the contract. In most Muslim marriages today, the meher is pronounced to the guests so that everyone hears how much the wife might be getting. The language used is analogous to the contract of sale, even though many Muslims disagree. Death and divorce feature as the two most prominent forms of separation between husband and wife. What is recognized is that even if divorce takes place before consummation, the wife is still entitled to half her meher. Islamic law bases its stance on the Quranic command, and if you divorce them before you have touched them and have already settled a dower on them, then you must pay them half of what you have settled. The juristic arguments centre on whether the wife should be entitled to anything at all, since the marriage was not consummated. Whether the wife could logically be entitled to the full meher, since the responsibility lies with the husband, who leaves his wife after choosing not to touch her. In similar circumstances, should the husband divorce his wife where no meher was specified, the wife is still entitled to a gift. It is a means of ensuring that her legal status as a wife is financially recognized. It can be assumed, therefore, that marriage is concluded by contract plus consummation. One without the other is not recognized as a marriage. In the event of death before consummation, however, the woman is entitled to a full meher because death implies conclusion of the contract. By the death of the husband, the marriage is rendered complete, for everything becomes established and confirmed by its completion and becomes established with respect to all its effects. Yet what is happening in many British Muslim communities is that the amount of meher which should be based on the woman's social and material background is often ignored in the guise of returning to a more frugal prophetic practice. The meher is getting smaller, even if the husband can afford to pay a higher meher, and yet at the same time, divorce is getting easier to pronounce. My contention is that what we are gradually witnessing is a kind of moral blindness, where any ethical dimensions of marriage and divorce are being eroded for the sake of quite simply making life easier for men. Men and women may be equally responsible for making marriage happy or unhappy, but that is not the issue here. Separation and divorce is recognized as a possible and legitimate consequence of any marriage, and legally speaking, there is no stigma attached on the divorced man or woman. But if texting or emailing a divorce becomes more widespread, then it will quite simply add more misery and humiliation to the vulnerable position in which most women find themselves at the end of a marriage, or when they are caught between two illegal systems called a limping marriage. The Quranic command to take them back in good manner or part with them in good manner has been completely ignored, but weight has been given to the husband's right to initiate the divorce as long as the sentiment stated is similar to the words expressed. I would argue that while texting is not the same and cannot be the same as a spoken word, it is a spoken word on which the classical tradition based its legal arguments. This issue has quite simply been dissolved by contemporary alims. The unilateral male right to talaq without any grounds outside of court and without the presence of two witnesses is one contentious provision which continues to set Sharia divorce apart from many other modern laws today. In 2006, Bastami Khair argued that while there is a tendency in Muslim countries to bring divorce procedures and grounds more into line with practices observed in the West, Muslim minorities in the West appear to be unhappy with Western civil law and call for the application of Islamic law. But the issue of texting a divorce would go against this trend, and furthermore brings into sharp focus the ever moving target, that is, gender equality. If women have gained rights in some areas of their lives, they have equally been deprived of a voice in others. Fiqh, or Islamic jurisprudence, followed its own discipline of logic and form, but was essentially socially constructed and not a sacred part of revealed religion. If fiqh does not expand in the areas of personal law to take into account women's humanity when dealing with such sensitive issues such as marriage and divorce, where do women go to align their religious loyalty with self-autonomy? Fiqh itself must be desacralized, not so that it can be relegated to the past, but precisely so that it can continue to provide a framework for discussions which connects with the tradition, but which recognizes and implements new ways of reform thinking about justice, equity, and most importantly, human compassion. Thank you.